Good morning. Welcome. Thank you all for being here at 9 o'clock in the morning. I'm Margot Kaminsky. I'm the faculty director at Silicon Flatirons for the Privacy Initiative, and it's my pleasure to welcome you here today for a conference on the near future of U.S. privacy law. We are at what some scholars are calling a potential constitutional moment for U.S. privacy. It represents a confluence of news stories, such as the story of Cambridge Analytica, state to federal dynamics, transatlantic developments and pressures, developments in Fourth Amendment law, and tensions and various alliances within and between the political parties. These various forces have been driving, for the first time in my career, really serious conversations about and proposals for implementing comprehensive data privacy law in some form in the United States. For those who are newer in this space, I want to provide some background. We do have privacy laws in the United States. Some of them, are at the state level, some are at the federal level, some are targeted at government actors, and some are targeted at private actors. These laws, however, are largely sectoral, by which I mean they apply to specific sectors, to particular kinds of information, or to particular institutions. Or they may be consumer protection laws, which protect individuals' privacy to some extent in the context of a purchase or other direct relationship to a business. Many of these laws, however, are relics of earlier pushes around earlier problems. And they exist in contrast with what most of the rest of the world does, which is omnibus data protection law. So if you come away with one set of jargony keywords, that is omnibus data protection law. Data protection law at an omnibus level covers all personal data, with some exceptions, and covers all sectors, rather than focusing, say, on the health sector, or on video use, or on children's privacy, as we do in the United States. It also follows data even to third parties, which is strange for most US privacy laws. So a data protection approach attaches if a company holds a piece of personal information about you, regardless of whether they have any kind of direct relationship with you. So the US does not do that. We have instead this hodgepodge of sectoral laws and state laws. And arguably, these are more specific, more targeted, and more responsive to particular harms than an omnibus data protection approach. What we also have plenty of, though, is gaps. We have gaps in what institutions are covered, gaps in what practices are addressed, and gaps in what kinds of harms are recognized. Take, for example, HIPAA, the Health Insurance Portability and Accountability Act, which nowhere in its title, although one of the strongest privacy laws in the United States, says the word privacy. HIPAA covers health information. It regulates health data, but only when it's held by certain categories or kinds of entities, like hospitals or pharmacists who take insurance. If you enter sensitive health information into a search engine, HIPAA's protections do not apply. Or take the data broker industry as a very commonly now recognized practice. Data brokers can gather immense dossiers of personal information about individuals, and an oddity of the consumer protection approach is that in focusing on a direct relationship between a consumer and a company, it misses these third parties who don't have direct relationships with consumers at all. Third, the US has long struggled with articulating a viable notion of privacy harm. As Dan Solov has put it, it's not visceral and it's not vested. You can't touch most privacy harms, or point to physical privacy scars, or to medical bills. And often we're talking not about a harm that's already happened, but a risk of some sort of injury of unknown imminence. And this problem runs through privacy laws in the US, defanging them from standing to sue at the first instance to calculations of damages. But something big is happening. Something like 2/3 of states in the past year have either proposed a version of omnibus data privacy law to some extent, meaning law covering all personal data in all sectors, across all institutions and most practices, or they've put in place serious legislative committees to study it. We've seen also a slew of regulatory proposals on the federal level. We've seen record fines at the Federal Trade Commission, yay, Federal Trade Commission, and we've seen bans on certain privacy-invasive technology by cities. This leads to 3 questions I hope we address today. The first is, what is driving all of this? Is it Europe's GDPR, or General Data Protection Regulation, which went into effect in May of 2018? Is the GDPR inspiring imitation in the United States, where US citizens look to their EU counterparts and say, we're jealous, we want to have some sort of privacy protection? Or is GDPR perhaps causing companies in the US to stand up less to data protection laws because they're already internalizing the cost of a comprehensive data protection regime, and they'd like to impose that cost on their regulatory competitors? Or is what's driving US privacy law the California Consumer Privacy Act, which was enacted a month after the GDPR went into effect and goes into effect this January 2020? Is California, rather than Europe, leading, as it did in emission standards, using the heft of the California economy and the location of Silicon Valley as a hook for serving as the de facto US privacy regulator? The second question is, what is good privacy law? What features should we bake into this wave of recent proposals, and what features are missing? We know now what EU privacy law looks like. What is the American version of data privacy? Finally, the Silicon Flatiron Center motto is "Know What's Next," and this conference is certainly in service of that motto. This conference is a window into what's happening in data privacy at a uniquely exciting time for privacy in this country. We can't claim to predict the future, but we do have some real insights in the short term on what path this current wave may take. So thank you for being here. I'm so honored to welcome all of you and to welcome all of our speakers who represent the best of cutting-edge conversations in this field. I'm very honored to welcome Commissioner Slaughter of the FTC as our keynote at what is a fascinating time for the FTC. I'd like to point out, too, the depth of expertise that Colorado law has both historically had in the subject matter area and currently continues to grow in, with thanks to my colleagues Amy Stepanovich, who is our new Executive Director of Silicon Flatirons, and Scott Skinner-Thompson, who will be leading discussions today. Most importantly, thank you to our students and our staff, especially to Heather Martin, I don't know where Heather is, for her behind-the-scenes work in making this all happen. And finally, a quick note, as a newer faculty member here, I've been most excited about the Silicon Flatirons tradition of having students ask the first question. So when we open up for conversation, please remember that students take priority, and students from my classes and present and the past, please take advantage of that opportunity. So welcome to the near future of US privacy law, and thank you all so much for being part of this exciting conversation today.
Good morning, everybody. I hope you can all hear me okay. It sounds like I'm being amplified adequately. My name is Amy Stepanovich. I am the Executive Director of Silicon Flatirons, a position I've had for about 5 weeks now. I'm incredibly excited to be here in Boulder, to be here at this conference. It's my first Silicon Flatirons conference I've got to attend in person and not watch on the live stream from Washington, D.C. So that's a great opportunity for me, and to get to see all of the faces here in person. This is a particularly interesting topic for me because up until I took this position, I was doing policy with Access Now and really deep in the trenches of the conversation around a federal privacy law. So now coming and having this conversation here with you and hearing what's happened since I left that space and what's going to happen going forward is quite fascinating, and it's a really exciting time, as Margot pointed out. You can tell the importance of the speakers to my left by the length of their titles, which I'm going to give. It's really impressive, the amount of expertise we have on stage today. To my immediate left is Ryan Kalo, I'm going to read these because they are quite long, the Lane Powell and D. Wayne Gittinger, Associate Professor at the University of Washington School of Law. We have Reed Next to him, Reed Freeman, who's the partner and co-chair of the cybersecurity and privacy practice, as well as the co-chair of the big data practice at WilmerHale. Next to him, we have Gus Hurwitz, the associate professor of law and co-director of space, cybersecurity, and telecom law at the University of Nebraska College of Law. Then we have Meg Lita Jones, the associate professor of communication, culture, and technology at Georgetown University. And at the end, last but definitely not least, Michelle Richardson, the director of the Privacy and Data Project at the Center for Democracy and Technology, or CDT. So I'm going to dive straight in and ask a question of each of our panelists to try to guide the initial part of this conversation, starting actually with Gus. Margot talked a bit about the Federal Trade Commission and their role in the exciting time that they have ahead of them. And in a way, the FTC Section 5 authority has been long disputed and continues to be disputed. Can you talk about the ways the FTC's approach has been working and where it may need to continue to be tweaked?
Absolutely. First, thank you for having me. It's great to be here. I especially appreciate and respect the bravery shown by the University of Colorado inviting someone from the University of Nebraska. You might be wondering, why is this person wearing a bright red shirt under their slightly unbuttoned blue dress shirt? It's because I've got my Nebraska colors on, and Michelle, excellent color choice. You might not know what you accidentally have walked into in Boulder this weekend. So the role of the FTC in privacy debates, the privacy discussion, is fascinating. It is challenging, difficult, incomplete, and accidental. Basically, in the late 1990s, there was privacy concern. We were starting to say, this online internet privacy stuff, it's a thing. And folks were trying to get their heads around it. The FTC suggested several times to Congress, hey, give us authority to do something about this, or Congress, you should do something about this. Congress never did. And over the course of the subsequent 10 years or so, the FTC turned to its UDAP authority, its Unfairness and Deceptive Acts and Practices Authority, to step in and fill a void that was felt to exist at the time and still today to address consumer privacy concerns. How effective has this been? It's been surprisingly effective, I would say. There has been a fair amount of success in really curtailing clearly problematic conduct, which I mean both at the individual actor level and more generally in the ecosystem. So using its unfairness, its deception authority, if a company says, hey, we're going to treat consumer information this way, and they don't, there might be a deception claim, and the FTC has very effectively taken enforcement action against companies in that case. And through that, they've established and really upped the level of understanding of what the baseline for good practices are. So the floor of privacy policy has really been raised by the FTC. That said, the FTC doesn't have clear authority to address a lot of emergent concerns, especially with the large companies, Facebook-style data practices. The deception authority can be unclear. The unfairness authority, there's a puzzle in unfairness when everyone is talking about how companies are engaged in practices that consumers might not like. It's hard to say. Generally, when we're talking about unfairness, we're talking about practices where a company is being secretive or duplicitous in their conduct. And when they're openly being duplicitous, it's kind of hard to fit this into an unfairness framework. Beyond that, a couple of challenges with where we are today. The harms are unclear. Margot spoke to this. She definitely didn't allege it because it's unquestionably the case that many harms are unclear. The benefits are unclear. When we're talking in the unfairness context, the FTC under Section 5N of the Act kind of has a cost-benefit analysis they're supposed to engage in. The changing state of norms, consumer understanding and expectation, what consumers are comfortable with, is unclear, and it's unclear how that should fit into the agency's analysis. And to add, one of the biggest issues right now that the Commission is starting to face, their ability to impose fines is dramatically unclear. This actually started a couple of years ago with a Supreme Court case involving the SEC, Kokesh. Basically, the FTC and the SEC historically have relied on equitable remedies under, for the FTC, Section 13B, in order to get monetary damages from companies. And a couple years ago, the Supreme Court said, hey, SEC, your statute doesn't clearly authorize those damages on an equitable basis. And over the last 9 months, 2 federal circuits, which had long interpreted 13B as allowing the FTC to get equitable monetary damages from companies, have said, the 7th and 3rd Circuit have said, you know what? No, the statute actually is pretty clear that you can only get injunctions. You can't get equitable damages. So that's a potentially really big stick that's been taken away from the FTC. The last thing that I will say, the FTC's entire mentality to dealing with privacy issues going back to the 1990s, and I don't mean this as a criticism of the FTC, they are in many ways an enforcement agency, and their history, especially since the 1970s, has been one of enforcement, not rulemaking, and certainly not kind of public-private partnership regulation models. They've had an enforcement model. Company, you did something wrong. You harmed consumers. We are going to take you to court. We are going to punish you. It's an inherently adversarial model. And I think in this sort of context, that's really problematic. The biggest thing that we need, and you can see this across almost any complex industry that consumers have difficulty understanding, that's complex to understand what the rules should be, we need trust. We need trust between the key industry players, between the regulators, between the advocates and advocacy groups, and most importantly, between consumers. And we don't have that when we approach these issues from a billy club enforcement model. I don't know how we change this. In the US context, and I think even more in the European context than the California context, the approach is companies, we don't like you, we're going to sue you. We're going to make it easier for consumers to sue you. It just ups the adversarial stake. And I think that we are in a negative feedback loop, and I don't know how we get out of that.
Thanks so much for that great rundown of kind of where we've come from, where we are. I do want to say we have jumped right into the wonky weeds of this conversation, and there is a lot of expertise in the room, but we want to make this open to all new entrants, old entrants to the conversation. If we on the stage use an acronym that anybody in the room is not familiar with, put a couple fingers up in the air, and that'll be a signal to us that we should probably spell out what that acronym means if we haven't done so already. So the other side that Margot introduced about the current state of play, we had the FTC, but then we also had this sectoral approach to privacy laws, as well as what is emerging as a state-by-state patchwork of laws, as it's been commonly referred to. I want to turn to Reed to talk about that environment and if a comprehensive or an omnibus privacy approach makes sense. And if so, what is the role of preemption in that conversation? Hot button topic, to say the least.
Well, thank you. And again, thank you for the kind invitation to be here today. I feel like a fish out of water because I'm the only law firm lawyer here. But the good news is I'm the only law firm lawyer here, and we're hiring, and you're students. So come by and let me know if you're interested, and we'll talk. Let me begin with state by state. There's a difference between sector-specific approaches and state-by-state approaches on individual topics. And let me begin with the comprehensive state privacy law, like the CCPA, well, the CCPA. That,
Can you put your phone? Oh, there's no phone.
You do have to turn off the wireless on devices.
Oh.
Not get interference with the mics. Yeah.
I'll just turn my phone off.
No screen time, guys.
That'll do it, well, at least from my perspective. The CCPA is the first, of course, comprehensive federal privacy law in the United States, and it's from a business perspective. Business is not.
Do you want to try? Turn off all the other mics except for that one? Yeah? Okay.
Well, I can't pull it any closer. I'll speak louder. All right. So this business is not opposed to a comprehensive federal privacy law as a general proposition. The problem with the CCPA is also not with respect to the backbone of the CCPA with respect to the consumer rights and business obligations. The problem with the CCPA is the definitions of personal information, of consumer, of unique identifiers, and so forth. It makes it almost impossible to do data mapping, which is the very first thing you need to do to be able to respond to a DSAR, a data subject access request. So that's the problem with the CCPA, and business and advocates and the legislature are trying to iron out some of the things. Business just wants to comply and know what it needs to do to comply and have a way to do it that's not so burdensome that it just can't be done. I don't think the California Attorney General could comply with the CCPA as written with respect only to his own website. But nevertheless, the comprehensive state privacy law is not a problem in and of itself until there are 2 or 3 or 4 or 5. That is when we run into a crisis from a business perspective, because of course they'll all be modeled on the CCPA, although the Washington bill was quite different, and they'll conflict, and this is the problem with state law in general for companies that have a national footprint. If we have multiple comprehensive privacy laws, and the Washington bill will come back in the next session, then I think we'll have a much stronger push for a federal comprehensive law. Now for specific topics, I think that the specific topics that states address is in general a good thing, because Congress is dysfunctional and has a difficult time passing discretionary legislation on a particular discrete topic. This is why the states, this is where the states play a good role. So you get, biometrics, facial recognition, social security numbers, sharing of information for direct marketing, the California and Delaware laws regarding privacy policies, and data breach notifications, the Song-Beverly Credit Card Act in California, which is quite restrictive, and so on. And these laws are by and large good, and business can comply with them until more than one state has a law on the same thing, and then we run into the same problem. So in general, business is this is a good thing, at least from business perspective, until there become conflicting laws. Now, sector by sector is much cleaner, I think. We have the Video Privacy Protection Act, we have GLBA, the Gramm-Leach-Bliley Act, and the Fair Credit Reporting Act, HIPAA, and the Children's Online Privacy Protection Act that are sector specific. And business over time has figured out a way to comply with these. And the only issue that I think is problematic with these laws is, and I'm sure the distinguished professors and folks from CDT would agree, I think fundamentally the flaw of GLBA is that it relies on a notice that's sent to you in the mail. The open rate of those is less than 0.5%. That's just the open rate. Nobody reads it. And so it's probably the world's biggest waste of paper. And I've heard FTC people say that before. That I think a notice regime of that ilk is not efficacious, and more can be done there. Finally, with respect to a comprehensive federal privacy law, so 3 times in my career since 1998 doing this, we have had a major push for a federal comprehensive privacy law, and 3 times it has died under its own weight because it's so big, and every affected industry comes in and says, yes, but not for me, yes, but I need this fix, and it just ends up dying. This time is different. This time, business wants it, Republicans want it, Democrats want it, advocates want it, everybody wants it. The problem is they all want it in different flavors. And you're right, Amy, the issue is, the pivotal issue is preemption. If there is, so in particular, preemption would be of not all privacy laws, but of comprehensive privacy laws like the CCPA. If business doesn't get that, I think business would walk away from the table, because it would just be another law that could potentially conflict with 12 other state laws. And so that is absolutely fundamentally critical. Secondly, the business will push hard for no private right of action. Everybody knows that, and so if the Democrats give in on preemption, business is going to have to give in on just about everything else. And I think you'll see, if it works out, a bill that comes into law that has the same type of backbone as the GDPR and the CCPA, but hopefully with better definitions.
So just on what has been introduced already, we could host probably an entire day's worth of conversations, and I've seen that, actually, especially when you start talking about the fact that preemption is not necessarily a yes-no proposition, but more of a sliding scale of where do you put that dial, because it can be written in so many different ways. But before we do that, let's continue to scene set a little bit, because the other big force in this space is, of course, Europe's General Data Protection Regulation, which went into effect in 2018, and we've seen implementation of that now, maybe failed implementation in some circumstances, entities who said that they won't implement it and have pulled out of the European market. So turning, Meg, to you, what lessons can we learn from the GDPR, and how might that approach be different from the approach that we end up taking here?
Thanks so much, Amy, and thanks, Margot, for inviting me. I'm going to answer this question by taking you all through a journey of the podcast that I listened to on the flight here. I promise it will, it's relevant. So I was listening to Kara Swisher's recent conversation with Ro Khanna, who's a representative for half of the Silicon Valley's district, California's 17th district. And he, after Cambridge Analytica, he's kind of a leading voice in the House on all things tech, and was asked to do something after the Cambridge Analytica scandal, and he and his team, of course, came up with the Internet Bill of Rights, which is sort of lost in the congressional chaos right now. But what he said to Kara Swisher, I think, says so much about the attitude that American policymakers take towards European regulation on tech. And I'm going to clean up his quote a little bit, but I'm going to try to read most of it. He said, "I don't think we should adopt the European standard. Europe has had, 2 tech companies in the last 30 years? They're almost irrelevant when it comes to technology. China is far more relevant. I would not listen to anyone in Europe about tech. It's a declining innovation culture." End quote. And I think that is really how American policymakers see their job as distinguishing any type of American policy from European policy. That it comes up over and over again, even though if you look at the Zuckerberg hearings, I think that they asked him about European regulation something like 8 times, and I'd never seen anything like that. But furthering you on my podcast journey, then I was listening to this podcast I really love called Tech EU, which is all about innovation in the European Union. And the first thing that they were talking about was this update on DeepMind, which is a UK, of course, everybody knows DeepMind. It's a brilliant UK AI company that was bought by Google. So it's an interesting example of European innovation that gets swallowed by American companies, and that's very frequently the case. And then they started talking about Starship, which makes robots. Ryan, how would you describe those robots?
I would say that they were land-based carts.
Yeah, exactly. That makes Ryan smile every time he says it, so I thought I'd give him that opportunity. And Starship is this robotics company that is out of Estonia. It's an Estonian and a Dutch-based innovator. But they went for a Series A just recently through an LA-based venture capital firm to distribute their robots on 100 US campuses. This was followed by a conversation about France's digital tax. So I don't know if you follow this, but this summer, France said it was going to impose a 3% digital tax. The White House got very mad and said that this was an unfairly targeting American companies, which I think thrilled the French people that idea probably sounded great. But then last week, the 2 governments struck a deal that the American companies that paid this tax would get it back when an international agreement was met, which is kind of a strange way to resolve an issue. But all of this is to say that American and European regulation and tech companies have always been entangled. They've always been aware of one another, and they've always sort of distinguished themselves around technology and innovation and the regulation around that. Each of those European countries and the United States and the EU have really, really wanted to dominate the computing industry since the 70s, and they've made really interesting pushes for that. And one of them is the single market in the 90s. And one of the things that they have in common, but I would not say as a European influence on the United States, is that compliance costs should be really low. So the driving force for the 95 directive was to make data protection comprehensive across all of these European countries, and the regulation was even more so to say, look, we don't want any variation. We really want a firm push across data practices and for compliance costs to drop. And so that is not an influence. Americans have been well aware of compliance costs in technology at the same time, but that is something that they share, and it's almost one of the only things that they share. I think that if you look at Ro Khanna's Internet Bill of Rights, the rhetoric of rights is, I think, a European influence. But if you look at the GDPR, those rights are all supplemented by a very long list of obligations on Data controllers, the GDPR is a very, very long law, and those obligations are not part of that Internet Bill of Rights. So it's really interesting. The American push, the American privacy push, I think that I see at the policy level right now is a privacy that does not burden companies or inventors or data controllers. It doesn't burden them. It would almost be something they don't really have to think about, but would provide increasing amounts of control through these list of rights. And I think that that is a very, very American way of doing things. Privacy is hard, but we gave it to you, and it's not going to be burdensome on something that is really near and dear to American policy right now, which is technical dominance.
Just a real quick follow-up. How many Internet Bills of Rights, Magna Cartas, constitutions, declarations have you seen?
Oh, yeah, we have a good chart. We have a chart of those. Do you mean internationally, or do you mean in the U.S.?
I think that answers the question. So everybody should get out your Silicon Flatiron's bingo card, because I'm about to say the last word and everybody's going to scream bingo. Cambridge Analytica has really triggered a lot of these conversations in the United States. So I'm looking at Ryan because I'm about to turn to him. How has that brought the idea of manipulation into the conversation, which is one of the big things that we're talking about trying to pass a law to address? And what other harms are we talking about? Can you bring us into that world, into the present conversations that are happening right now?
Sure. So I want to echo my fellow panelists in saying it's a great honor to be here at Silicon Flatirons. I consider this to be just one of the premier places for law and technology discussion in an academic space with a huge policy impact and relevance. And I think it's wonderful that you're here at the helm, and I can only envision great things going forward. So I've been doing privacy. I've been thinking about privacy for not as long as a lot of people in this room, for maybe about 12 years. And during that period of time, I've seen each successive year a ratcheting up of scrutiny of what tech companies are up to. I've seen greater fines, more laws, more interest, more workshops, obviously what's going on in Europe and so on, in California and so on. So each successive year, there's been more attention, more scrutiny, more brought to bear on this question. And each successive year, if you look at, for example, the Pew Internet surveys, Americans have become more concerned about privacy every single year. What's going on there? Well, one story is, of course, that it's become more salient. Newspapers are talking about it, the government's talking about it, and so it's on people's minds. But another possible interpretation, which is my own perhaps idiosyncratic interpretation, is that we're actually not, with these variety of efforts, getting at the root problem. And the root problem, in my view, is the absolutely enormous disparity of power and information between industry and the consumer, which has just grown over and over and over again by many, many, many different folds, right? So what does it consist of? Well, it consists of the fact that industry, the tech industry I'm speaking about here primarily, knows so much more about you as the individual consumer than you know about them. But it's not just that they have access to an unbelievable amount of information, it's also that they structure every aspect of your interaction with them. You know, it's not like Apple goes to a website that you designed from scratch to sell you music, right? It's not like Uber makes a match between you and a driver based on terms that you set, right? So they have all this information and they completely structure the interaction. In recent years, you bring to bear powerful techniques of artificial intelligence like machine learning, and then they can leverage that great asymmetry of information and power to an even vastly greater degree. So what I believe is happening is that the American consumer, not necessarily being well informed, but neither dumb nor lacking common sense, is sitting there thinking, I am probably getting taken advantage of, right? That's what you're thinking. You're sitting there going, I don't know precisely how. It's not my job to say precisely how, but something's happening to me. I'm paying more. I'm behaving in ways I don't want to behave. You know, I'm sharing information I didn't want to share. I'm being taken advantage of. And unless we get to that root problem, that nothing we're doing is going to address the growing problems that, the growing sense of unease that we experience. So the question then becomes, how do we address a problem like that? Which is dramatized by Cambridge Analytica. I mean, I think a great problem with that is the feeling that people have that, gosh, we got taken advantage of. We were manipulated. Our information was weaponized, against us. Well, I want to take you back to the origin of consumer protection law. So with Alex Rosenblatt, she's an ethnographer at Data and Society. She and I wrote a paper a couple of years ago about basically the sharing economy and some of these dramatic asymmetries of power and information and how they play out in the context of Uber and Lyft and Airbnb and the like. And one of the things, for this project, we had occasion to go back and look at the legislative record around some of the original consumer protection interventions, right, 100 and some odd years ago. And if you look at those interventions, what you see people saying on the floor of the Senate and the House is that consumers are not able to play on a level playing field, that there's a huge asymmetry of power from companies. And to allow companies to leverage their enormous asymmetry of power over people is immoral. And some of the language that you see around unfairness meant literal unfairness. And some of the language about the public interest meant the public interest. There was a recognition in these early laws that the idea was that it was not moral for enormous companies to be able to take advantage of consumers in the way that they have. Okay? Now, I'm not an activist. I maybe sound like I'm talking like one. If you read my work, a lot of my interventions suggestions are modest. I take corporate money from my lab, from Microsoft. I believe in these companies. I believe in the innovation that they're doing. But if you want to get at the problem here, you need to address these asymmetries. So I'm agnostic as to precisely how we go about doing this. But one of the major sea changes that has to happen is that bodies like the Federal Trade Commission need to have the staff, the expertise, the political mandate to go after companies and figure out what it is that they're doing, draw lines, and say that those lines cannot be crossed. And if they're crossed, they must be heavily fined. Now, if you listen to what I'm saying, there's a little bit of a tension between the comments I'm making and Gus's comments, wherein he talks about how the whole problem is that we have an enforcement mentality and that's no way to live. But my own view is that unless we really get into these practices and start to sort out what's okay and what's not okay, we're never going to have the government be able to intervene on behalf of the consumer, and consumers are going to continue to be more and more concerned. So Cambridge Analytica is an example, but there's all kinds of things going on out there that are not okay. Some by really major, huge players. I think relatively few are by those big players that are maturing over time. A lot of terrible things are happening with smaller players who do not have the same kinds of incentives and so on. And so, whether it's an FTC that has the staff and the political will and the capability of passing rules, a rulemaking authority, clear rulemaking authority, an FTC that uses its substantial subpoena power, its substantial power to go in and ask industries and individual firms directed questions to figure out what they're doing, right? Until that starts to happen and we draw some lines saying, this is too far, this is against the public interest, this is unfair, in a classic sense of unfair, I don't think we get at the problems that we're seeing. End sermon, apologies, but that's sort of my take on what's going on.
Okay, can I make a quick observation?
Yeah.
Okay, so of course I have to jump in and make I'll try and be quick. I said quick.
Please.
Observation. First, fascinating. Ryan and I are saying the exact same thing in very different ways. These consumers know they're being screwed over by these companies. They're being taken. They don't trust the companies. There's no trust there. It's the exact same thing from different perspectives. I want to just add a comment, the history of consumer protection and antitrust as well. It's very incoherent. There absolutely are voices in the legislative history. Congress is a they, not an it. There are voices in the legislative history, both the FTC, antitrust law, other consumer protection laws that absolutely echo Ryan's points of perspective and what he's saying he finds in it. There are others that take a different approach. There's an entire subsequent history of unfairness in the United States that we, for this conversation, need to elide over, but it's a complex history. But the point I want to make is the FTC's initial mandate wasn't as an enforcement agency. It was basically go research and inform Congress. You have the authority to conduct studies of how these industries work. We have problems. We know there are issues. Tell us what laws to pass. So it wasn't a you guys have the enforcement prerogative. It was we get it. We need to do something. Help us figure out what we need to do, which is trust. And of course, in that era, we were in a different regulatory mindset, and we were spinning out, then starting to spin out lots of regulatory paradigms where we had more direct industry oversight. So interesting that we're saying the same thing, but you're wrong. I say jovially.
All right, let's, I feel like we've kind of, I'm gonna adopt Meg's word, gone on a journey here from where these conversations have started and some of the origins through today, and looking ahead, Michelle, between the CCPA and the GDPR, which we've talked about, there's definitely pressure now to come up with a federal legislative proposal, although we're getting to the end of the year before an election year, and the attention is getting divided and split. But there are, I think on my last count, at least 10 different bills that have been introduced to address this in part. What would you say are the strongest proposals? Can you summarize what's out there, and where are, and I think Reed started to get at this, the biggest points of both agreement and disagreement within the space?
Sure. So this is just such an exciting time to be working on privacy legislation. If you go back even just a couple of years, legislation on privacy was literally a sentence or two that said, FTC, go make rules on privacy and security. And Congress now, especially after Cambridge Analytica and CCPA, is very interested in writing a comprehensive statute and taking on the very difficult but important task of actually writing the rules. And that is going to be the most important thing here, is that Congress make the policy decisions here, right? There will be a role for the FTC in some form and in some scope to write rules, but I think the fight really is in Congress. And that's how we're going to slingshot forward here, right? We don't want more, we want different. There are no number of attorneys you can give the FTC. If the type of cases they bring stay the same, if we are only in a post hoc enforcement mechanism. And so the most important thing right now is for Congress to write clear rules up front of what is appropriate in the collection, use, and sharing of data, which is very complicated. It's very hard, but Congress is taking it seriously. So there are probably a couple dozen bills, if you look at ones that touch on different pieces of the issue, either introduced or published by Congress, probably a couple dozen more from groups like mine or industry. A lot of those are still private. So there's not a shortage of options or language out there. And we are definitely post principles at this point. We are at a point where it's sort of text is table stakes, right? And Congress is really trying to draft and put pen to paper what it looks like. And they've come very far over the last couple of years. You know, those Facebook hearings a little over a year ago now showed a real lack of familiarity with how technology or the internet works. That is not the case anymore. Congress is asking very serious questions. I almost fell out of my chair when Republican Chairman Graham of the Judiciary Committee opened a hearing by saying to the Google witness, I want to know how much money you make off of online behavioral advertising versus contextual-based advertising, because I might ban the former. And so we are in a different world now. Congress is very serious. They are catching up here on how this works and what's at stake. I would say some of the major proposals are still outstanding. That's what's important to know. Congress is very top-down, so you need to wait to see what some of the chairmen and ranking members on the committees of jurisdiction put out. And this is, I don't know, likely later in September. We're hoping, knock on wood, maybe October. And there are many stakeholders involved that will come to play once the text comes out. So it will evolve over time. There's agreement in a few areas. One is on individual rights, that there should be some constellation of access, correction, and deletion rights. Some of this is in California, some of it is not. It exists in some of our sectoral laws, it's in Europe, and there'll be some fight over the details, but this is now presumed that would be in any law. Transparency. There are two transparency goals here that I think Congress is aiming at that people agree are accurate. One would be how you inform a user at the moment when they sign up or use a product about how it's going to work. But are there also maybe annual reports or broader transparency for academics and attorneys and advocacy groups that have much more details so they can understand how things work? Greater authorities for the FTC, like original finding authority, and probably more staff and resources. And AG enforcement. I think people realize it is both the right thing to do, but on a practical matter, very necessary to have the states enforcing the single standard themselves. It sounds like a lot, but really, this is not enough to get a federal law passed, those lists of agreements. It's still more than California, frankly. But I think as Professor Kaminsky's article points out, it's still far less than GDPR, and it is far less than a comprehensive look at how data is actually collected, used, and shared, right? It really leaves the onus on users to try to micromanage their relationship with hundreds, if not thousands of companies who touch their data every day. It doesn't fundamentally rebalance the power between users and companies. And so this sort of constellation of issues is really not going to be enough to make fundamental change, systemic change in how companies use our data. And that comes to where there's still a little disagreement. This is usually more about data use, getting beyond that notice and choice, what you collect, but once the company has it, what can they do with it, right? Beyond what is necessary for actually offering the service you signed up for, what is an appropriate use of data? This often really delves into either advertising, if you're on an advertising model, or product development, and you want to find out what your next great product is. And there are a couple of issues that are on the table right now. One would be creating a sort of a red light list of prohibited uses of data. For us at CDT, this is something like prohibiting the secondary use of sensitive data like biometrics or location information. Discrimination issues are hot right now also. There is a concern that, especially with artificial intelligence and machine learning, data use is now so opaque and it reinforces discriminatory behavior that it is only going to get worse and close to impossible to enforce our existing civil rights laws. All of these used to apply to brick and mortar facilities, real people interactions, but now it happens on a computer and it's having a lot of the same outcomes. And so how could a law address these sorts of problems? And then there's data security. It hasn't gotten nearly as much attention over the last year, and when people were presuming this all could happen before January 1, there were some proposals to deal with data security separately. I think that is probably unlikely to happen, and that there will be data security in this bill, especially now that it looks like it will take into next year at least. To address things, though, about preemption and private rights of action. These are really two sides of the same coin that are very, very controversial, but they're both going to have to be addressed in some way. And I think they're the two that there has been the least work on. Right now, people often talk about them in very black and white terms, like it's an on or off switch, and neither of them need to be. There are many options that Congress could use in drafting a statute for both of these sections. But on a very practical level, you're going to have preemption issues to get companies and Republicans to be supportive, and you're going to have a private right of action in some form to get more progressive members to support legislation. So that's a long to-do list, still outstanding. But there are a lot of people working on it, and I will say, I think there's a lot of hand-wringing in the press that because the bill isn't available now, it won't be done, or they're not close. I think in the next couple of months, we're going to see really comprehensive bills introduced. And a reminder, this is a long process. Far simpler topics took many, many years to resolve. And so we are making a big jump forward here. I really think we are with the hearings, the bills that are coming, the markups. It's hard to put an actual end date of how quickly we can get this done, but if you look at other social justice movements, because for us that's what it is, they really did take decades to do. All the attention kind of focuses in on the last 3 to 5 years, and new players and getting things over the line, but they really took a long time. So I am just hoping that, that we're on year 15 or 18 as opposed to year 1 or 2 in the arc of what we are trying to do here. And it will happen. I'm hoping that it happens in the next couple of years, and I think that is still a realistic possibility if everybody comes to the table.
So I have a really, really long list of questions, but I've been watching the head nodding and the head shaking in the audience, so I assume that you guys are all chomping at the bit to ask your own questions. We do have students who will be walking around with mics. I will take moderator's prerogative and ask something, so I want to give you like the heads up. We're about to turn to you all. Have your questions ready, but I want to kind of make some subtext across the panel, actual text, because privacy discussions impact different communities differently, and the regulatory environment can have huge impacts on those communities. And notably, I think some of them are not generally represented in these conversations. How have you interacted with the communities who may be more largely felt on these topics? What can we do to bring them into the conversation? And what are the impacts if we don't do that? I'll just start with, I'm going to put Ryan on the spot here because he happens to be sitting next to me, and go down and see if any of you have thoughts about that.
Yeah, I mean, I think that, one of the leading concerns with artificial intelligence and with the far greater use and the acceleration of artificial intelligence is that the costs and benefits of AI are not being evenly distributed across society. And I worry very much with Michelle and CDT and others that certain populations will feel the harms of artificial intelligence as it's used to experiment upon them and on their bodies and in their communities, even as others who are far more privileged derive the benefits of those things. I am very much convinced by the work of folks like Scott Skinner-Thompson here and Kiara Bridges and others, that people who are vulnerable, people of color, many other communities are scrutinized far more intensely in exchange for the kinds of access to products and services that they need and so on, right? So there are these great disparities. How do you address it? That's a very difficult question. My own lab, the Tech Policy Lab, we have a process that's called Diverse Voices, where we take our early stage work product and our white papers and so on, and we run it by panels of experiential experts. So these are people who are living with, maybe they are part of a non-mainstream community, maybe they are particularly vulnerable. So for example, we might run our white paper by people who are formerly incarcerated or people living with disability. And what we ask these experiential experts whom we pay and who have a mixture of both studying the issue and living and having the lived experience, we ask them what's broken about this document. And then we have qualitative highly trained information scientists gather thoughts about that, and then we integrate it into our final work product. That's one method that we use with our own, right? But it's a non-trivial problem, and I would totally associate myself with your remarks that these voices are not adequately represented in these conversations.
I never know when to keep my mouth shut, so I'll say something. In my work, I very frequently focus on unintended consequences and the like. So a couple of thoughts on this. First, in many ways, the privacy discussion is a first world problem sort of discussion. Absolutely, I have to start by saying absolutely there are disadvantaged and minority communities that can and are exploited in terms of privacy practices. On the other hand, there's a lot of reason to think that the perspectives that are, the voices that are most loudly represented in these discussions are those who don't feel those concerns. And it's not just about disadvantaged and underrepresented voices. This is a period of changing equilibrium, changing social values and norms, and it's frankly older people, and I don't mean elderly people, I mean people who are not growing up today, in high school today, in college today, that are having discussions about the shape of the technologies that are going to be used over the next 2-3 generations. If you look at the results of GDPR, this is a bit of a transition topic-wise, we have seen Liad Wagman at the University of Illinois. He's done some empirical work on the startup community effects of GDPR. And two of the things that we've seen, a flight of investment out of Europe following GDPR, increasing compliance costs, as Reed spoke to in the US context, has decreased investment, forced investment to other countries, perhaps some to the United States, perhaps some to other countries, China, that have very different investment, different privacy priorities. We've also seen a ossification and increase in market power of the big advertising platforms in Europe because they're the ones that can afford compliance costs. So we've seen a strengthening of the monopoly platforms, a reduction in competition. If we're concerned about market power in these industries, generally regulation benefits the incumbent market players. And I am really concerned about the externality effects of privacy protection. One of the things, I don't know whether or not this is true, but one of the things that talking to medical researchers, I've been told by many, several researchers, is but for HIPAA, or if HIPAA was different and allowed more ready sharing of medical information about patients, we could have cured many cancers a decade ago. That's a pretty powerful externality. Is the fact that I'm embarrassed about my medical conditions a good reason to say that I can keep that secret if my sharing that information could help save other people from serious medical conditions? That's not something that we focus on in most of these discussions. How we balance that with the really deleterious, really adverse, abusive practices, it's hard. I am worried that as we focus on the abusive practices, the clearly problematic practices in discussion of regulation, that these, the other side of the story is going to be left out of the discussion.
And to answer your first question, Amy, we are trying to do outreach to groups who might be most affected, and it's hard to explain just how gross some of the things that are happening with data. The FTC did a report on data brokers quite a few years ago now, but you know, they were finding things that people were being targeted for a category called Speedy Gonzalez, which were Latinos who are in financial distress, that you should probably point exploitive products at them. I mean, these types of things that are happening right now, they're very hard to track, and I don't think we're going to be able to stop them without a comprehensive privacy law. There are too many actors, there really are. It's so opaque, and despite what some folks said earlier, a recent GAO study said that there really have only been about 10 enforcement cases over the last decade at the FTC on pure privacy outside of the existing regulatory system like COPPA. So there actually aren't many of these cases, and they are all very specific to the companies and the data use. And so we are not going to get around to some of the most abusive practices and offensive things, I think, until we do a statute that deals directly with it. It's tough, but I think Congress is sincerely interested in those issues. But, to follow up, this is the problem. This is why we don't have a privacy law. People say things like we would have cured cancer if we don't have privacy laws. This is ridiculous. That's of course not true. There's no information to actually support that. There are ways to conduct research under peer-reviewed processes that allow broad access to information. And there are advancements in technology every day that support anonymization and other things that actually protect human beings while allowing for pretty progressive uses of data. And this is the thing, right? So as much as we hear people say, companies would give up anything for preemption, not true. That's not what they're saying on the Hill. I would have my bill done by now if that was the only thing people cared about. They are simultaneously trying to fight over what those appropriate data uses are. It's complex, it's hard, but this is what's happening, right? We're not having an honest discussion about what are the fair limits to put on the use of data. Are there protections we can build in so we still get the benefits, right? I think all of us want the benefits of that data, and what do they look like? That's hard, it's complicated, but that's going to be what's necessary to get a federal law and something that really is progressive and forward-looking and is going to withstand the test of time.
Well, notwithstanding being rebuked by Michelle on my theory of federal privacy legislation, I think that she hit the key problem squarely in her opening remarks, and that is the unexpected, unanticipated secondary uses of data, whether it's uses or sharing, in context. Now, she's also right that the FTC hasn't brought as many enforcement cases as you would think given the ecosystem now. But as a private practitioner, I can tell you they investigate an awful lot of them, and they close an awful lot of them where they don't find that they have that they don't think they'll win. And so they are active and they are learning. So with secondary uses, with more FTC enforcement, I think that could go a long way even before a comprehensive privacy law. So the standard that the FTC set in its 2012 privacy report was, and in some cases that they brought, is that if a use in context would surprise an ordinary user, then putting it in the privacy policy is not sufficient notice to the consumer. Why? Because it's unexpected. Why would my mother look to the privacy policy for something that she doesn't expect will happen? It makes no sense. So they have said since 2012 and in cases since then that unexpected secondary uses of data, and in particular sensitive data, have to be disclosed at the point of collection clearly and conspicuously for the consumer before the consumer enters her personal information or the personal information is collected passively through user agent data and similar methods. So more enforcement on that, I think, is important. When I advise clients, I say, well, this is what you say, and you've now told me what you do. If I told my mother those two things and asked her, would you be surprised? I think she'd say yes. My next question would be, happy surprised or sad surprised? And if she says sad surprised, and I do actually sometimes call my mother, and because my mother, I think, is the ordinary consumer. She uses the internet to invite me to dinner and to book travel to the Caribbean. So that's it. And and if she says she'd be surprised, and unhappily so, I tell the client it's illegal. And the reason is because the reason is that from a practitioner's perspective, this is all anticipatory law. The business is so far ahead of regulation and enforcement that anytime, I never get asked a question for something where there is a law or a statute or even a case on point. I have to extrapolate what's been done already to what the FTC or other regulators or Congress or whoever, AGs, will do when they get there. And so that paradigm of unexpected uses and out-of-policy disclosures, clearly and conspicuously at the point of collection, I think, is a good paradigm. The only other thing I wanted to say is, with respect to a comprehensive privacy law, there are three problems I see with FTC authority. I don't think there's any debate that the FTC should have more money and more people in the Division of Privacy and Identity Protection, enforcing, investigating and enforcing. No question about that. I don't think anybody disputes that. But rulemaking authority. Since 2002, when the FTC brought its first security case, they've refused multiple requests by business to say, tell me, what exactly is reasonable security, and I will do it. The FTC has wisely said no, because the threat landscape changes all the time. And so now the FTC is asking for rulemaking authority. And my question for them is, what would you say? You've already said you can't say it. And so I don't know what would happen with that. The other problem with rules is, once you establish a rule, it would be in this law through an APA rulemaking, not Magnus and Moss, which is cumbersome rulemaking the FTC has already. It's hard to change a rule. It takes a long time. And the dynamic in the marketplace is changing so fast that I'm afraid rules on specific issues would be obsolete. And finally, and the most important thing in a comprehensive privacy law is, it seems to have gone unchallenged by anyone that the FTC should have civil penalty enforcement authority in the first instance in a Section 5 case. Section 5 is a statute in equity. The FTC cannot get civil penalties in a privacy or data security case that isn't under a trade regulation rule. On the table is that the FTC would be able to get civil penalties in privacy and data security cases. On the face of it, that sounds fine, until you think about the numbers. Civil penalties are up to $41,000 per violation. Think about a data breach. It's not uncommon for a data breach to involve a million records. If the FTC believes that the security was unreasonable or violated whatever trade regulation rule they come up with, that's $41 billion. And nobody has raised that yet, as far as I know, but that's a problem. That's too much authority for the FTC. Any company that thought it had a defense would be foolish to try to litigate it, because you can't bankrupt a company with civil penalties, but you sure can cripple it. And that amount of civil penalty authority, I think Section 5 civil penalty authority should be a different number than civil penalty authority when they enforce a trade regulation rule or a order.
So we're going to turn to questions, and the mics will be coming around. Let's all conspire together to keep questions, and to keep questions and answers succinct so we can get through as many as possible in the time that we have left. We're going to turn to a student first, as Margot indicated. So in the back with the mic.
Ask the
first question. My name, is it now? Now? No? It's on. Okay. My name is Sarah Rippey. I am a third year here at Colorado Law. And you talked a little bit about different definitions and the challenges associated with that. So my question is, how do you create a definition, especially for personal data and sensitive data, that's both broad enough to accomplish the goal and actually have a meaningful impact, and narrow enough not to encompass everything? And especially with biometric data and personal and sensitive information, that's changing, and technology is changing the way that that's defined. So how do you allow for growth in that?
We would recommend that instead of thinking what should be in and outside of the law, everything gets in, and then you think about what duty is due to the different types of data. Because once it's outside of the statute, you have big problems. So we think the FTC's original formulation of this, that is the basis of California and other places, federal laws we're seeing about linkable to a person, is fine. It's hard, right? You either give the FTC authority to change the definitions of sensitive data over time, or you take your best guess now, right, and say a statute that has clear rules for 80 or 90% of sensitive data is still such a game-changing step forward. You take it, right, because now it's just on a case-by-case basis. I think we're comfortable with the latter. We know that that could be under-inclusive and over-inclusive, like you said, but we're just going to have to accept that we're going to have to update this law every 10 or 15 years. That's good governance, no matter what the topic is, and that will make sure the law stays fresh.
This is a fascinating question, and in many ways it goes to the heart of why this is such a difficult issue. This area is changing so rapidly over the course of less than a single generation, and we're in a highly regulated, highly statutory era of governance. If you look at comparable issues, if you look at fiduciaries, for instance, and a lot of folks have suggested we treat privacy through a fiduciary sort of rule. These are rules that have evolved through a common law process, lots of small cases over generations. And if I had a magic wand and a time machine, that's what my solution to privacy would be. I've got no idea what the right answers are, and I guarantee you that anything we do today will be wrong, and 15 years from now, we'll be updating it. This is also why I think a omnibus approach is a terrible idea. We need an incrementalist approach over a period of many years, and how we do that today is really hard. The idea 15 years from now, we're going to update massive federal legislation. I would love it if that were a practical solution. It would be great if we can get legislation through at some point of any form. I'll say that today because I'm scared to death of the California legislation, which is a relatively non-incremental, I'll say, instead of omnibus. So I don't have an answer, but understanding, thinking about how we respond to, we don't know what the answers today are. Probably the right answers today will be the wrong answers 5 years from now, 10, 15 years from now. How we design, this isn't about privacy, this is how we design statutes, how we design legal rules through a legislative process that can be responsive to highly dynamic environments. We don't have a good way to do that.
So I'm going to take two questions just so we can get in as many as I can. And the first two hands I saw when I first asked for questions were these two right here. So, and then I have here and here for the next round.
Hi, thank you. Can you hear me? Okay. First of all, I just want to say I'm just a little disappointed in the approach that we're discussing these laws. We have companies that have said that they want to go right up to the creepy line but not pass over it. We have situations happening where, I mean, people say, well, I don't have anything to hide, but let's say, for example, I'm a mother that has a teenage son who has started buying makeup and girls' clothing. you know, a woman who got a pizza delivered with a note on the side of it that said, son died in a car accident, right? I mean, we have these companies, so many companies collecting so much data on everyone and creating new products with AI that do facial recognition software. We're not even having a discussion of who owns my personal data. I do, right? I mean, these companies don't have the right to make money by infringing on my rights. I mean, the United States needs to really think about, do we have a right to our own privacy, even though we walk out in public, even though we walk into a store, something like that? Who owns this data? They don't get to do anything they want with this data just because someone has said, you know, I can make money by doing this. You're taking away my right to make money. I mean, are we having a discussion about who actually owns my data? I would think it would be me. And is anyone coming up with that definition?
Hi, thank you. My question is for Professor Hurwitz specifically. I had a different question, but I want to ask a question to what you had just said about advocating an incremental kind of evolutionary common law style approach. How would that work in our system, given that litigation can take, you know, years to happen, and that the large kind of settlements that we increasingly see instead of a verdict don't really have any sort of precedental value to shape privacy law or regulations going forward? I mean, it seems like the technology will just continue to leapfrog past what little precedental litigation actually happens.
So why don't we take the other two? Because we're only going to have time to go down the row once and have you all out. So down in front and then over here in the blue shirt, and then we'll do answers along with final remarks from all of you. Thank you.
I guess I'd first direct this at Ryan, but I'd like to hear any comments from the whole panel. I think Ryan touched on the issue of the disparity of power and the moral issue of fairness underneath this, and particularly there was reference to the Cambridge Analytica issues. There's a book published this year by Harvard professor Zuboff, Shoshana Zuboff, titled Surveillance Capitalism, that goes directly to these issues. It's a seminal piece of work. I wonder if anyone on the panel has read it, or if Ryan, if you've read it. I think it's right on target with your comments, but let that go.
Hi. So I'm a computer science student, and I know very little about policy, so I apologize if this sounds ignorant. But I wanted to ask, do you think part of the problem with the unequal playing field that you might be talking about, or with Congress not passing the right legislation, would be technologists, engineers, developers not being infused in Congress enough? And do you think there's a push for that now? Yeah, thank you.
So why don't we start with Michelle in the red shirt, and then come down to the right.
Is this a football thing?
Yeah.
Is that what we keep talking about? Okay. Sorry about that, everyone. I'm actually a CU grad from my undergrad, so deep apologies. I will just say, yes, I think we would invite people to reach out to Congress more. They're probably more accessible than you think. You have some actually really savvy members in Colorado, too. So reach out to them while they're at home during recess, send letters, and it means a lot coming from constituents, especially when you're providing such specific information like this. And I think what we like to see from people with tech background is to explain that actually, yes, a lot of the things we're asking for when we're talking about protecting people's information is technically possible. It can be built. Those options already exist. And so it is us coming to a society saying that we as individuals deserve them and they have to be built into our products. And I think that would be helpful for me as a privacy advocate.
Yeah, I just want to respond to the first question and kind of share the the disappointment. I mostly do comparative work, and so kind of come from this as a user myself. You know, my scholarship is not exactly that, but my major disappointment in the push. I'm really excited about the push for legislation, but I'm really disappointed that it's stuck in a consumer rhetoric. I'm not a consumer of almost any of these services. I don't do business with them at all, but they have a lot of my data. And so the consumer rhetoric, I think, limits us to this notice and choice. How do we perfect the consumer relationship? And the GDPR is sort of the exact opposite. It's all about power, to Ryan's point. It's very explicitly about power, and I don't know that it will achieve any type of balance, but that's the point, and it's very much outside of the consumer language. I think when I hear the Consumer Bill of Rights, I think, oh, it's just another sectoral example. This will be my health data law. This will be when I'm a consumer. But what about all the rest of the time that I'm sharing data or I'm out in public? And so I would love to see a push and a change to embrace, like, there was a new voter privacy bill that came out that seems different than consumer privacy. But this is, we're worried about Cambridge Analytica, which is both somehow consumer and privacy. And so I would love the bills that are going to come out in the next couple of months to be meaningfully about individuals and not about consumers.
So first, the question is directly to me. My answer is a very frustrating, I don't know. This entire industry, it's a perfect storm of impossible trade-offs. National, international scale, natural monopolies that are completely opaque to most consumers in an environment where we don't have lots of a laboratory of states sort of environment that we can rely on. It's really hard. What I would, I'll give a pitch to both Margot and Meg. Several of us yesterday were involved in a workshop talking about law and technology, and one of the future projects is kind of the toolbox for how we regulate. I would love it if we had a toolbox that allowed us to write legislation that had some form of non-destructive sunset clause in there that said, hey, Congress, we need to revisit this in another 5 years, another 10 years. And hey, industry, you can't use that to exploit this systematically. So I think that we need to look to a better and new, more dynamic statutory tools that we're working to develop, that we're talking about developing. To the other 3 questions, I actually have kind of a single response. I spend a lot of time. I'm generally the crazy person on these panels. From the perspective of most other panelists and the audience, kind of, yeah, the tech industry, I'm kind of championing, we shouldn't be regulating them, hands off. And I always say with friends like these, that is, friends like Mark Zuckerberg, who needs enemies? Because the tech industry is always trying to go right up to that line without crossing it. They're surveillance capitalism. They're doing all this stuff. We can't trust them. And frankly, we shouldn't trust them. I actually say the problem isn't a lack of expertise in Congress. It's we need to be educating. We need to educate computer scientists and entrepreneurs in a different way. And a lot of places here, this is certainly a big part of computer science interdisciplinary curriculum at Nebraska. We're really thinking about how can we change the curriculum to improve how we're designing the technology. Because if we're trying to address these problems on the back end, it's too late. First off, the cat's already out of the bag. More importantly, we can't re-engineer these technologies, and we've lost trust in the industry. It's up to the industry not to lose trust. If the industry loses trust, the regulatory sledgehammer comes down. And it's a sledgehammer. It's always going to be destructive. And kind of, I guess, going back to the question directed at me, we might be in the sledgehammer realm. There might be nothing that we can do to regain trust. We might need to have very substantial omnibus regulation and legislation come down, and then 10, 15 years from now, hope that a phoenix can arise from those ashes.
We're a bit over time. Can Reed and Ryan, you quickly bring us home?
Well, first, I'll just say I do think one of the problems is a lack of expertise in Congress. When Mr. Zuckerberg testified, one of the questions he got was, Mr. Zuckerberg, I'm confused. Your service is free. How exactly do you make money? He said after 2 full weeks of prep, and did not throw his phone at the senator. Instead, he said, thank you for your question, sir. We sell advertising. And so that was sort of an astonishing question. I think that there's so many issues floating around. I really think that we have to focus on, like, what are we trying to fix? What we're trying to fix is what you mentioned, which is the information asymmetry. And to me, legally, that means secondary uses, unanticipated uses, sensitive data uses, and giving consumers notice that they understand, that they see, they read, they can take action on, and maybe in some cases will be required to opt in to those uses. And I'll just stop there.
Yeah, I mean, in the interest of time, to say that this has been a fascinating discussion. I have read that book. Maybe I'll end on this note. I think it's really important that we remember that as a society collectively, we can really change the way that we decide to live. And over the last hundreds of years, American society has done that a number of different times. And it may be that partly because of technology, partly because of social norms and other kinds of differences, partly because of all the shocks that we've endured to our system, it's a time now of great renewal. And we don't need to just keep the status quo being precisely what it is. And I would ask you to be mindful of the rhetoric that you choose to deploy and the way that words keep us in the present paradigm. And so I don't mean it all to be critical, but I would note that when you talk about data as ours, our property, I completely agree with you at one level. On the other hand, property is some fungible thing that can be traded away with enough, something being attractive enough. When you talk about surveillance capitalism, it starts to seem like maybe the problem isn't capitalism, it's just the fact that it's surveillance capitalism, right? In other words, if you want to see change, if you want a paradigm shift, be careful what you talk, how you talk, and also demand more. We can fundamentally decide that we don't want to live this way, and that's a possibility.
All right, thank you all. Huge thanks to our panelists. A big round of applause. Thanks for bearing with us. Thanks for coming out early.